I want to just touch on a couple of the rulings, the three big rulings that took place today with the Supreme Court. The first one was in regards to Citizens United. When we spoke to former Senator Russ Feingold, he felt pretty confident at the time. And I think there's been at least one other senator I've spoken to. We're fairly confident that this case coming out of Montana, where the Montana Supreme Court ruled in American Tradition Partnership v. Bullock, the Montana Supreme Court ruled that corporate money, despite what was found by the Supreme Court, that as a matter of fact, it is their experience in Montana that corporate money, unrestricted corporate donations to campaigns, corrupts their political process. And as such, despite the fact that there was a different ruling in Citizens United, the Montana Supreme Court ruled that their laws, which prevent corporations from giving unlimited amount of funds to campaigns, will stand. And like I say, Russ Feingold had some measure of confidence that the court was going to revisit this case, was going to use Montana as an opportunity to revisit Supreme Court, the Citizens United ruling, because it has been shown in many aspects to have been completely misguided. The idea that there would be full disclosure, the idea that it wouldn't implicate our political process, the idea that none of this is corrupting, all of that. In just a few short months, it would have been clear based upon just what we saw in the Republican primary. But sadly, no. The court ruled, essentially, I believe it was 5-4, that the Citizens United ruling would stand. They reversed the Montana court's finding. And I think it was Breyer in the dissent. Well, he did not want to, I guess it was per curiam. They granted the certification and then reversed the Montana case. Breyer and Ginsburg and Sotomayor and Kagan dissented. In Citizens United v. Federal Election Commission, the court concluded that independent expenditures, including those made by corporations, do not give rise to corruption or appearance of corruption. And Breyer, writing, said, I disagree with the court's holding for the reason expressed in Justice Stevens' dissent. In that case, as Justice Stevens explained, technically independent expenditures can be corrupting in much the same way as direct contributions. In other words, we all know the super PAC thing is a joke. And just because it's supposedly independent from the campaign, we know it's a joke. Breyer goes on to write, indeed, Justice Stevens recounted a substantial body of evidence suggesting that many corporate independent expenditures had become essentially interchangeable with direct contributions in their capacity to generate quid pro quo arrangements. And as Senator Sheldon Whitehouse said in our interview from last week, he said, the other part of the problem is not just that there's a quid pro quo, but that when that lobbyist for Corporation X shows up in your office and says, I want you to vote this way, there is an implicit threat that, hey, I can go take $5 million out of our corporation's general fund and dump it into a campaign attacking you. So it's not just I spend money and you give me the vote I want. It is if you don't give me the vote I want, I spend money but against you. Breyer goes on to write, moreover, even if I were to accept Citizens United, this court's legal conclusion should not bar the Montana Supreme Court's finding made on the record before it. In other words, saying their factual record is different than ours. There was no factual record in ours in many respects. That independent expenditures by corporations did, in fact, lead to corruption or the appearance of corruption in Montana. Given the history and political landscape in Montana, that court concluded that the state had a compelling interest in limiting independent expenditures by corporations. So what Breyer's basically saying to the rest of the court here is that you may think that in the context of American politics, this type of money is not corrupting, but that should not preclude you for saying that, well, in Montana, they have a special case. In Montana, they've actually found that, yes, political money was corrupting. Breyer continues, thus Montana's experience, like considerable experience elsewhere since the court's decision in Citizens United, casts grave doubt on the court's supposition that independent expenditures do not corrupt or appear to do so. Were the matter up to me, writes Justice Breyer, I would vote to grant the petition for certiorari in order to reconsider Citizens United, or at least its application in this case. But given the court's per curam disposition, I do not see a significant possibility of reconsideration. Consequently, I vote instead to deny the petition. In other words, he was basically saying, like, I would rather just deny the case based upon the fact that I know you guys are going to overrule it and wait until there's some sanity on this court.